Thank you very much. Yeah, thank you for having me. I'm going to talk about the role of the Federal Constitutional Court in Germany in implementing the convention in Germany. So Karlsruhe, Strasbourg, Karlsruhe, it's really very close, just across the Rhine River. But that is only geographically speaking. But does this short distance also mean that the Federal Constitutional Court stands for a smooth, efficient, and effective implementation of the convention? Well, I will take a look at how the German Federal Constitutional Court has been and is handling today's transnational legal pluralism with regard to Strasbourg, that is, with regard to the convention, and to the case law of the European Court of Human Rights. The reason I'm focusing on the Constitutional Court is rather obvious. Because of our individual complaint procedure and the obligation under Article 35 of the Convention to exhaust domestic remedies, basically all cases, really all cases which are brought to the court in Strasbourg have been dealt with before by the Federal Constitutional Court. In the first part, I will describe the beginnings of the Strasbourg Court's case law with regard to Germany. I will then point out the reasons for the reluctance at first within the German legal community, which was actually widespread, to accept the convention and apply it. And in the third part, I will explain with the help of 3 example cases the way Germany and especially the Constitutional Court handled and overcame these difficulties. Let's start with the good old days. For a very long time, the Federal Constitutional Court had good reason to believe that there was actually no need to take any specific action regarding the implementation of the convention. After all, the German Constitution, our basic law, and its interpretation by the Constitutional Court in Karlsruhe was proving to be a success story. And that had already started in 1951, that is 9 years before the Strasbourg Court even handed down its first judgment. This success story, one could say, is evident simply from the fact that during the first 43 years after having recognized the right to individual petition, that is from 1955 to 1998, Germany was found to have violated the convention only 15 times. That's an average of merely 1 violation every 3 years. Of course, the reason for the low violation rate might also be found in a less active European Court of Human Rights back in those days. In any case, it was nothing really to worry about. However, the rate of violation judgments against Germany increased considerably in the following 13 years, up to an average of 11 judgments every year. And now there were more and more spectacular judgments, which attracted attention within and outside the legal community. There was the Caroline von Hanover case, we already talked about that yesterday, regarding the freedom of the press guaranteed by Article 10 and the conflicting right to privacy of Article 8. There was the case of the kidnapper Gafgen concerning the right to a fair trial after having been subjected to inhuman treatment as prohibited by Article 3. And there was the case of M versus Germany, which dealt with the question of the retroactive extension of preventive detention in violation of Article 7, only to name a few. At first, the German courts, including the German Federal Constitutional Court, were reluctant to accept this international interference. In my opinion, this reluctance was for the most part based on what I call attitude and lack of knowledge, as well as linguistic and dogmatic distance. Let me shortly explain what I mean by that. Germany has been and is, quite rightly in my humble opinion, convinced that due to the basic law and its implementation and enforcement by the Constitutional Court, it already has a pretty excellent human rights protection, which is rather very similar to the system provided for by the Convention. The attitude, therefore, essentially was, we don't really need the Convention, or the Strasbourg Court. The lack of knowledge resulted from the fact that public international law, until around 1998, tended to be sidelined in the German legal culture. It did not form part of the compulsory curriculum at law school and was rarely publicly discussed. You had, of course, specialists in academia, but the majority of the legal community, especially the judiciary, did not pay too much attention to this field of the law. One could say legal thinking took place only within national borders. But the main reason for the reluctant reception was most likely the language barrier. Decisions and judgments of the Strasbourg Court had for a long time been available only in English or French. Translations into German were scarce. Hence, the judiciary did not pay attention to the judgments because the judges simply could not read them. Fortunately, translations as well as summaries of the most important cases have over the years become increasingly more common. But even today, there still is the dogmatic distance, which should not be underestimated in my opinion. The wording of judgments and decisions, the style of writing of the Strasbourg court is quite different from judgments of German courts and makes it a difficult read for the German educated lawyer. It needs time to get used to that. Despite these difficulties, the dialogue between the Strasbourg court and the German courts, especially the Federal Constitutional Court, has become increasingly substantial over the years, thereby assisting effective implementation of the Convention. After introducing you to some legal preconditions, I want to illustrate this dialogue and the resulting effective implementation by way of example. The European Convention for the Protection of Human Rights and Fundamental Freedoms leaves it to the contracting states how to ensure the effective implementation of the Convention and the rights contained therein. In Germany, as I mentioned yesterday, the Convention only has the status of a federal law. German courts must observe and apply the Convention, of course, because it's a law. But it ranks below the basic law, the German Constitution. This has made reception of the Convention and the Strasbourg Court's case law into German constitutional law a methodological challenge, quite a challenging word. However, the Federal Constitutional Court has accepted and dealt with that challenge. It found a way to incorporate into its case law the standards of the Convention as well as its interpretation by the Strasbourg Court. Namely, the Constitutional Court argues that the Convention's constitutional significance follows from the basic law's openness and commitment to public international law. The Court today consistently holds that the guarantees of the Convention influence the interpretation of the fundamental rights and constitutional principles of the basic law. The text of the Convention and the case law of the European Court of Human Rights serve, on the level of constitutional law, as interpreting guidelines when determining the content and scope of fundamental rights and constitutional principles of the basic law. Even though the Federal Constitutional Court has in this way since the 1980s already drawn on the Convention as well as the case law of the Strasbourg Court, it was not until 2004 that the Convention and the Strasbourg Court really got the Constitutional Court's attention, starting with the Caroline von Hanover case. And I think it's only since around maybe 2008 that the Constitutional Court consistently and explicitly refers to the Convention and the Strasbourg Court's case law in its judgments and decisions. This in turn has led to a high degree of harmonization of convention rights and the fundamental rights of the basic law, and hence an effective implementation of the Convention in Germany. Let me clarify the Constitutional Court's approach with the help of 3 example cases. The already mentioned Caroline von Hanover case, the also already mentioned Gerberü case, and the case of M versus Germany. As Judge Nussberger, the German judge at the Strasbourg Court right now, once put it, these 3 cases exemplify the relationship between the 2 courts in Karlsruhe and Strasbourg. In addition, these cases also illustrate how the Federal Constitutional Court has accepted its role as executor of the Strasbourg Court's judgment. The Caroline von Hanover judgment by the Strasbourg Court in 2004 concerned the protection of celebrities against the intrusion of the media into their private life and required a balancing exercise of the right to private life against the freedom of the press. You probably already all know that already. The controversy between Karlsruhe and Strasbourg revolved around whether and to what extent the level of protection of Article 8 may vary in relation to, let's say, the level of celebrity of the person photographed and written about. The Strasbourg Court did not accept the jurisprudence of the German Supreme Court, the Supreme Civil Court, which had been confirmed by the Constitutional Court. And this case law of Germany's highest civil court tolerated reports and photos of celebrities' private lives to a greater extent if the celebrity was considered a so-called figure of contemporary society par excellence. So if they were really very, very, very prominent, you could basically take a picture and write about them almost in any circumstances. But then after the Strasbourg Court, as a consequence and in compliance with Article 46 of the Convention, our Supreme Court modified its case law as to the limited protection of certain celebrities and developed a concept of gradual protection, taking into account the criteria developed by the Strasbourg Court. And then in 2008, the Constitutional Court approved this revised jurisprudence explicitly with a view to the constitutionally relevant directives of the European Court of Human Rights. And then the result of this new balancing exercise between freedom of expression and the right to private life, as undertaken by the German courts, was then subsequently in 2012 accepted by the Strasbourg Court. Also in 2004, the famous Gergely decision was handed down by the Constitutional Court. It dealt with the access and contact rights of a biological father whose child had been given up for adoption without him knowing. The Court of Appeal of Naumburg had, in a rather infamous decision, denied the father contact rights even after the Strasbourg Court had found exactly that to be in violation of Article 8. The Court of Appeal, so it's not my Court of Appeal, had argued that only Germany, but not its courts, was bound by the judgment of the Strasbourg Court. When that case was brought before the Constitutional Court, it did not only clearly state that German courts are, of course, bound by the case law of the European Court of Human Rights, but that the Convention and the Strasbourg Court's case law actually constitute part of its own standard of review. And it said, and I quote, "The binding effect of a decision of the European Court of Human Rights extends to all state bodies and in principle imposes on these an obligation to end a continuing violation of the Convention and to create a situation that complies with the Convention. Courts are, at all events, under a duty to take into account the judgment that relates to a case already decided by them if they preside over a retrial and are able to take the judgment into account without a violation of substantive law." It went on to say, "Against this background, it must at all events be possible, on the basis of the relevant fundamental right, to raise the objection in proceedings before the Federal Constitutional Court that state bodies disregarded or failed to take into account a decision of the European Court of Human Rights. In this process, the fundamental right is closely connected to the primacy of law embodied in the principle of the rule of law, under which all state bodies are bound by legislation and law within their competence." End of quote. The possible limits of an implementation of a judgment of the Strasbourg Court were also described by the Constitutional Court as follows, and I'm afraid that this passage was probably cited by the Russian Constitutional Court. And the Constitutional Court in Germany said, "The binding effect of statute and law also includes a duty to take into account the guarantees of the Convention and the decisions of the European Court of Human Rights as part of a methodologically justifiable interpretation of the law. Both a failure to consider a decision of the European Court of Human Rights and the enforcement of such a decision in a schematic way in violation of prior ranking law may violate fundamental rights in conjunction with the principle of the rule of law." End of quote. But, it had already been mentioned, I think, by Max, so far these limitations have not had to be enforced, and I actually can hardly think of a case or situation in which a judgment of the Strasbourg Court cannot be taken into account because it would result in a methodologically not justifiable interpretation of the law. I will have an example later on. Actually, in the following case, the M versus Germany. That's the most recent example of effective implementation of the Convention. It's the 2011 preventive detention judgment of the Federal Constitutional Court. It had to deal for the second time with the elimination of the former 10-year maximum period for preventive detention and the application of this new legislation to the so-called old cases. The decision by the Constitutional Court had become necessary after the Strasbourg Court's judgment in the case of M versus Germany of 17 December 2009. In this judgment, the European Court had found that the retroactive application of the new legislation to old cases violated Articles 5 and 7 of the Convention. Once the judgment had become final in March 2010 because the government's request to refer the case to the Grand Chamber was rejected, the German courts found themselves in a dilemma. The lower courts. They were not only faced with the judgment of the Strasbourg Court, which they knew after Gergely they had to consider, but also with a conflicting 2004 judgment of the Constitutional Court, which has in Germany final and binding effect. And in this 2004 judgment, the Constitutional Court had found the relevant provisions to be constitutional. But the dilemma was resolved only 1 year later. On 4 May 2011, the Second Senate of the Constitutional Court handed down another judgment and now held the relevant provisions of the criminal code to be in breach of the basic law. With regard to the final and binding effect of its already mentioned 2004 judgment, it had to take a procedural detour. The Constitutional Court argued that judgments of the Strasbourg Court can amount to legally relevant changes, which may then lead to a reversal of the final and binding effect of a previous decision. This procedural flexibility and active reception of the Convention, that's how the current president of the Constitutional Court, Andreas Voskuhle, has put it, leaves room for new developments on the European level. On the merits, the court analyzed the Strasbourg Court's case law in detail and found the relevant provisions of the German criminal code to be unconstitutional. It took into account the applicant's right to liberty and the legitimate expectations which it found to have an increased weight because of the applicant's rights under the Convention. As in the Gergely decision, the Constitutional Court again emphasized the basic law's openness to public international law and the obligation to take into account the Convention as applied and interpreted by the European Court of Human Rights. And now I think it's worth pointing out that while the Federal Constitutional Court's final result was the same as the European Court's, it did not accept the Strasbourg Court's legal qualification of preventive detention as a penalty within the meaning of Article 7 of the Convention. I don't want to go into details of German criminal law because I'm not a criminal law judge, but this shows that even case law, which at first glance seems to be in conflict with basic preconditions of the German legal system, can be adapted within the above-mentioned limits of methodologically justifiable interpretation. So even in this case, the Constitutional Court did not enforce these limitations it had formulated in the Gergely decision. In a later decision, the Constitutional Court, regarding the possibility to reserve the right to order preventive detention, shows that even if there is no explicit case law of the Strasbourg Court, the Federal Constitutional Court now examines that court's case law in detail and interprets the basic law with a view to the Convention standards. Such an explicit and in-depth analysis of the Strasbourg Court's case law not only lays the groundwork for a dialogue through case law between the courts, a detailed and critical analysis of the Strasbourg Court's case law also helps to avoid or clarify misunderstandings or misconceptions. Moreover, in its jurisprudence, the German Federal Constitutional Court acts as an interpreter and translator of the judgments and decisions of the European Court of Human Rights for the lower courts, but also for the public and especially politics. All of this is, in my opinion, one, if not the key, to an effective implementation of the Convention in Germany. I hope that these three examples have illustrated that the Constitutional Court has, over the years, willingly or unwillingly, become something like the executor of the Strasbourg Court's case law in Germany. While the legislator, from time to time, did also react to judgments from Strasbourg without having to be prompted by the Constitutional Court, it was that court that also often triggered changes in the legislation or the case law. There might be a good reason for that. With its cassation power as regards legislation as well as court decisions, the Constitutional Court in Germany has at its disposal quite effective instruments to change the case law of the Federal Court of Justice, but also to declare null and void laws. In the Caroline von Hanover case, it assisted the change of the case law of the Federal Court of Justice. In the Gergely case, it explicitly instructed the Court of Appeal of Naumburg to comply with the Convention and the Strasbourg Court's case law. It furthermore accepted the Convention and the relevant case law of the European Court of Human Rights as an additional standard of review. And in M versus Germany, it did not only accept the European Court's judgment, it revised its earlier decision and formulated clear guidelines for the legislator. All of this shows, I believe, very clearly that the implementation of the Convention is in pretty good hands, as well as in pretty good shape in Germany. And what is more, I think one can say that the Constitutional Court's work has led to an alleviation of the Strasbourg Court's caseload and strengthened the subsidiarity principle. Thank you very much.